230,815 women were diagnosed with breast cancer, according to the Centers for Disease Control and Prevention, for the most current year's statistics, and that year is 2013. On December the 18th, 2015, the defendant's doctor's office set up an appointment with a patient who had concerns regarding a lump in her breast. The appointment was set for January the 2nd, 2016. And on that day, the defendant nurse took down all of the patient's insurance information. The defendant nurse also took down information regarding the patient's complaints. After noting the complaints and taking the vitals, the defendant nurse informed the doctor that the patient was ready to be seen. The defendant doctor saw the patient 30 minutes after the defendant nurse. The defendant went over the noted complaints with the patient. Upon completion of a conversation with the patient regarding her complaints, the defendant doctor moved to perform a breast examination on the patient. The defendant doctor concluded after the breast examination that although a lump was present, the wait and see approach would be better in this situation. Hello, I'm Marcus Boston, and I'm a medical malpractice and childbirth injury attorney practicing law here in the state of Maryland. And I would like to quickly talk with you today about the basis of that opening statement what I just gave you. And the question which stems out of all of this is, under Maryland law, is a opening statement considered evidence or proof of medical malpractice when we are talking about a Maryland medical malpractice jury trial? Well, the short answer to the question is no. Your attorney's opening statement is not evidence that the jury is going to consider as proof of medical malpractice. See, under Maryland law, for a jury to be able to consider evidence, that evidence has to be properly submitted and it has to be properly admitted into evidence pursuant to the Maryland rules of evidence and other procedural rules. The judge in the trial is going to make that determination as to the admissibility of evidence. And when we are talking about an opening statement under Maryland law, that your attorney's opening statement is not going to be considered evidence. What that opening statement did is it gave a roadmap to the jury for them to be able to understand some of the critical issues which are going to be present in this case. For example, they know that this is a case about breast cancer. They know that a defendant doctor and nurse did an examination of the patient. They know that the defendant doctor did find a lump in this case. They know that the defense or the defendant doctor said that in this situation, the wait and see approach would be best. In other words, a roadmap was laid out for the jury as to some of the critical issues that are going to be present. Because we know that a doctor cannot needlessly endanger their patient. And in this case, you didn't hear anything that was done by the defendant doctor or nurse in regards to the patient's medical history, the family history, which is very important in cases like this. And if a proper history would have been taken, it would have been learned that the patient's aunts had suffered from breast cancer and the patient's grandmother had dealt with breast cancer. So in other words, breast cancer had run in this family. So why have I taken the time today to talk with you about this very important information? Because if you're watching this video, more than likely you have questions about the Maryland medical malpractice process. And although I was talking about a possible breast cancer misdiagnosis issue here, you may be watching this video because you had an issue with the surgery, or you have a child that has suffered an injury at birth and now you're wondering what's going on, or maybe a loved one has died and you have questions. If you have questions and concerns about these types of issues, and these things happen here in the state of Maryland, this is what I invite you to do. Go ahead and pick up the phone and give me a call. It costs you absolutely nothing to call me. I answer Maryland medical malpractice and childbirth injury and wrongful death questions just like yours all the time. You can reach me at 301-850-4832. Or if you prefer, you can send me an email to medicalinjury@bostonlawllc.com. All right, that's going to be it for today's quick educational video. Again, I'm Marcus Boston, and I'm one of the medical malpractice and childbirth injury attorneys here at Boston Law Group LLC, and we will see you next time. Take care and enjoy the rest of your day.